It's time for Work Comp Talk. Coming to you from the Pacific Workers Studio in Concord, California. It's Work Comp Talk. Interesting people talking about the issues that affect the lives of the everyday people that keep our communities moving. Sponsored by Pacific Workers Compensation Law Center, the lawyers for injured workers. With offices in Concord and Oakland, Pacific Workers is the leader in California workers' compensation, representing injured workers throughout Northern California. PacificWorkers.com, the lawyers for injured workers. Now to your hosts, Eric and Carmen.
Hi guys, welcome to our Facebook Live Q&A session. Joining us today is Bilal Kassem, Managing Attorney for Pacific Workers. We have a pretty interesting topic that we wanted to reach out and spread a little bit more or shed a little more light onto. And that is, Eric, if you may, tell us the topic for today.
Well, thank you. And this is also going to be saved as a Work Comp Talk podcast. And our guest here today is Bilal Kassem, Managing Attorney at Pacific Workers Compensation Law Center, which in full disclosure, we actually all work for and is the sponsor of Work Comp Talk. We've only had one person on before. That was, sorry, I'm getting a little bit of water here. That was from Pacific Workers, and that's actually Bilal. Our topic today is, can you get workers' compensation after being terminated from work, which is now very much a hot topic, and we're getting called quite a bit about this. So we thought we'd have a Q&A and do a podcast at the same time, getting this going. We are all working remotely, so we are not in the Pacific Workers Studios out in Concord, California today. And you can probably see that Carmen's office in Concord is not painted with such a nice tree, and Bilal doesn't have that photo in his office. So this is Facebook Live and Work Comp Talk, and Bilal, thanks for being here.
Thanks for having me on. So termination and entitlement to benefits has become a really hot topic, as you'd said, since this COVID-19 virus came out. There's been a lot of companies that have been able to weather the storm and others that haven't. And a lot of companies have done what they can in order to cut costs and reduce their financial liability to ensure the health and viability of the company afterwards. And unfortunately, that has meant that the employees are oftentimes the first to go. I'm sure you guys have seen recently, there's been record numbers of unemployment applications throughout the country that have far surpassed anything we've seen in history. Last time I checked, it was something like over 6 million unemployment applications.
I think it's 16.
16. And so a lot of those people are people who are healthy and able to work, and there's others that have been on modified duty and under workers' comp cases that have been on work restrictions, and their employer has been accommodating those work restrictions, but for the fact that the virus came around. You know, the interesting topic in general in workers' comp is whether people are entitled to benefits when they're terminated or laid off, regardless of the virus in particular. So, you know, starting off with that, you know, normally if you are terminated for cause and your employer was accommodating your work restrictions, you wouldn't be able to collect the benefits. So, for example, if an employee was caught stealing or embezzling company property and the employee was terminated, that would preclude the employee from getting the benefits. However, in other circumstances where the employee is not let go for cause or laid off for cause, they may be still entitled to the benefits depending on the facts of the case. So, for example, normally the employer has the obligation to ensure that they are offering permanent modified work, or at least some temporary modified work within the employee's work restrictions. If the employer can't do that, then the employee is entitled to temporary total disability, which is 2/3 their average weekly wage. Now, if an employer cannot accommodate those work restrictions, then the employee would get the benefits for as long as they need to recover, up to 104 weeks in most cases. The employee can go back to work at any point in time, provided the employer has modified work available to them. If they can't provide that modified work, then that time continues on until the employee has maxed out their benefits. So
let me,
right now we're really,
let me ask you a question. Let me try and break it down, because and we'll do this from basic, sort of the basic example. You can get workers' compensation after you've been terminated, right?
Yes, of course.
Yeah.
And, if an employer or insurance carrier is telling you otherwise, they're not being honest and forthcoming, and they're not doing their due diligence to really look into it. In some circumstances, they can be denied, but there's a lot of times where the employee is told that they can't, but they are well within their right to collect the benefit.
So let's say you're on TTD, total temporary disability, and so you're not working because you're on disability, you're getting your checks, and then all of a sudden the company closes, like a restaurant. Do you still get paid those temporary disability checks?
Yes, and so when you're talking to individuals, when you're looking at a case and determining whether or not someone's entitled to benefits, you really have to separate their employment from their right to benefits, as well as the health and welfare of the company and the company's operations. In most cases, companies are insured for workers' comp, which means the benefit that they're receiving in the form of temporary disability is not coming from company payments. It's not company assets or financials. It's the insurance carrier who's providing coverage for the employer. So as long as the insurance carrier is solvent, the insurance company should be paying the benefits regardless of whether or not the employer goes under. And so when we're determining whether or not someone's entitled to the ongoing benefits, we're really looking at, one, did the employer offer modified work within the work restrictions? Or alternatively, has their doctor told them to be off work completely? And two, how much are they entitled to? And that's, again, 2/3 their average weekly wage. Mm-hmm. So the employer's viability doesn't really matter. If the insurance company, for example, were to go to bankrupt, there's a entity in California known as the California Insurance Guarantee Association. We refer to it as CIGA, and it's a quasi-government entity that's meant to fill in or step in the shoes of insolvent insurance companies and assume their financial liability for the injured workers' benefits.
So that's if the insurance company goes under, is that right?
Correct.
Yeah. If the company goes under, it just closes its doors, files for bankruptcy, how does that affect things?
It really wouldn't. The only question is whether or not they offered at least temporary modified work when the employee turned in work restrictions. The employer has the obligation in order to make that offer of modified work. If they cannot, be it because they don't have a position available, because they're no longer solvent, because they're laying people off, then that essentially becomes the employer's liability, because the employer then cannot say they've offered modified work if they're closing their doors.
Got it.
And so it's not the employee's obligation to reach out and hunt for jobs and try and find work within their work restrictions. Their only obligation is to produce those modified work restrictions to their employer. Once the employer declines or can't accept, then it's the employee's right to benefits.
Got it. Okay, that's pretty clear. This subject has come up a lot, just over the last few weeks, and certainly with a lot of our clients. I know that this has come up, but also just we see it so often where people come to us and they say, "Look, I got terminated from my job, but I actually got injured and I was too scared to say something before, so I worked through the pain." There are some requirements if you're going to file for a workers' comp case after you're terminated. Can you add in a little bit and tell us a little bit about those, about what that is exactly? Because it's not cut and dry, right?
Sure. So we see it every day. There's people who are injured at work. They're really motivated to keep their job. They don't necessarily want to pursue the case because they're scared of being terminated or laid off because of work restrictions or just limitations in general. Or, they're just trying to be cooperative, good company person. They've got a good relationship with the employer and they don't necessarily want to pursue the case just because they're afraid that they may lose their job or something else. It may sour their relationship with their employer, or maybe they just didn't have the opportunity to report the case. There's a lot of injuries that are catastrophic and leave people incapacitated or just physically unable to physically report a case. Normally they turn in something called a DWC-1 claim form, which is just a standard state form for reporting an injury. If you're in a hospital, of course, or coma or some other condition, you cannot possibly fill out that form. And so in between the time you're injured and between the time you actually report your injury, if you've finally molded over and decided to or become physically able to, you may have been let go or terminated. In that particular time frame, the question becomes, well, how could you have possibly reported the injury? Now, the employer will say, well, you didn't report the injury because so much time went by and now you're terminated. And so because you reported the injury after your termination or layoff, it's barred by statute, which in California, we have a law that says if you are injured before you receive a notice of termination or layoff, and then you subsequently report the injury, that you're unable to collect benefits. And that's not entirely true all the time. And oftentimes the employer themselves has knowledge of the injury. Maybe they don't have the claim form, but they weren't stupid. A manager or some other colleague said, hey, did you see Joe fall 30 feet from that ladder? And the employer obviously knows about it. It was reported to them. They have vested knowledge. And so once the employer has vested knowledge from any source, it's sufficient notice to preserve the individual's right to proceed with the claim.
Whether or not they filled out the DWC-1 form. That's
correct. And the knowledge can be from any source. It could be a colleague telling their manager, hey, this person was injured, or, the manager not even being told, but specifically witnessing it, or even just having to exercise reasonable diligence to determine whether or not someone was in fact injured, right, and whether or not it was, occurring at work. The other exception would be if someone actually seeks medical treatment. So, for example, if your medical records reflect that you had gone to a doctor prior to your notice of termination and layoff, and there's a notation in the medical report that indicates you had a work injury, that itself would be sufficient as well to protect them from a post-termination defense as well.
That's great. Okay. Well, do we have any questions or anything come up there, Carmen?
No, we don't have any questions yet, but we do have a couple of viewers. So we want to thank you guys for joining us on Facebook Live. As a reminder, we will be having links to some of the blogs and information we are talking about today within the comment thread from this Facebook Live, as well as our podcast Facebook page, which is Work Comp Talk. So you can definitely jump on there. On the website, Pacific Workers, exists tons of blogs that you can also read, get a ton of information. If you have any more questions or would like us to talk about something specifically, just drop down a comment on this live, and we can also create a webinar for it, since every Wednesday we will be featuring a new webinar in our Facebook Lives.
We just have to be able to convince Bilal to show back up every Wednesday at 1 o'clock. Is that okay with you, Bilal?
Yeah, I'm sure that's fine. And actually, I'd like to add some stuff in if you guys don't mind. I was just thinking there's a lot of times, especially now, where employees are being asked to sign documents and attest to things that they don't necessarily believe is true or accurate, and oftentimes their jobs and therefore their life are being threatened by their employer. Be it signing a statement that they weren't hurt at work, or being told to report an injury actually happening at home rather than in the workplace, or signing a severance agreement in exchange for essentially dropping their right to pursue legal action against the employer. I caution a lot of people, it's much easier to work through these issues on the front end than it is on the back end. Please don't sign anything that you're not comfortable with signing. If you have questions for your employer, ask questions. If your questions aren't answered clearly and you're still not sure what to do, I do urge you, please do contact, a legal professional to help you work through the problems in order to make sure you're making a good decision for both your family and yourself. So, please don't sign anything you're not sure about.
And we see this a lot, and we have a lot of viewers that actually have lawyers at other places. And it's important to just make sure that you talk to your lawyer about it, and you make sure to get those, you get that good information. I am working from home, so I now have, my dog gets a little rambunctious at times, but I think he's calmed down already. So, but this is important because a lot of people do watch us from other, from other law firms and other places. We are California based, and the stuff that we talk about here is California based. I know we have people that watch us and watch our videos as far away as France. We were just looking at that this morning, France and Germany, and we have a bunch of viewers from Canada that stop in and look at our stuff quite often. This is specific to California, and I want to be clear, especially for our podcast guests. This is specific stuff to California. you should really talk to your lawyer that you have. You can always reach out to us as well. We might be able to find you a lawyer in another state, and I'm not sure about another country, but another state. We have plenty of connections around the country. We're very we're very robust in the stuff that we do and our participation across the country in various workers' comp industry professional networks and things like that. To find more about Bilal, who's the managing attorney at Pacific Workers, you can go to pacificworkers.com is probably the easiest way. Carmen is right. We've got about 200 blogs of various levels of information on all these types of topics, and we've decided that we're going to start getting these things out through the podcast and through our webinar Wednesdays. So, Bilal, I want to thank you. Unless we've got somebody that has a question before we jump off of here.
No questions yet, but I also do want to add in, a lot of people are afraid to even reach out to an attorney, to a lawyer, to a professional. They think, oh my God, how much is this going to cost me? Can I even afford it? So I think it'd be very important to kind of give them an idea of what happens when you do reach out to an attorney. Do you have to pay them? So maybe we can explain that a little bit for them.
Sure. I'll jump in on that because it's pretty simple. In workers' comp in California and most places in the country, it costs nothing to go. It's a contingency fee basis, and it's the same with almost I know it's the same with every lawyer in California because it's part of state code, that it is contingency and it should cost absolutely nothing. And there's a lot of fraud in the workers' comp world in California. So if anybody wants money up front or they want something in exchange for signing up, just walk away. There's plenty of very good lawyers out there. We certainly have some worthy rivals and competitors, and there's plenty of them out there. So just walk away from any kind of situation like that. It should be somewhere between 12 and 15% on workers' comp for the general workers' comp cases. There are some minor exceptions to that, but it should be all contingent. And so any lawyer in California should be willing to give you some time to talk about your case. And I know that that's what they do at Pacific Workers, where we are. And but it's not going to cost you anything. You even get reimbursed for things like mileage and any cost that you have with regards to it. So it's a great question. We could do a whole thing just on that. And we probably should. So, but if we don't have anything else, why don't you sign us off for the podcast? People watching on Facebook might go, what are you guys doing? But we're combining this one because we're getting a lot of questions with regards to this with all the mass layoffs going on right now. So why don't you sign us off?
That is right. So we want to thank you guys for joining us, and make sure you follow us everywhere on social media. You can find us under Pacific Workers Compensation Law Center here in Facebook. You can also find us on Instagram. We're on Twitter. We're on every social media platform you can think of, including YouTube. And you can also find the podcast under Work Comp Talk. And that's also on Facebook, Instagram, any social media you can think of, including YouTube. Bilal, thank you so much for joining us today. Very, very great information. And if you have any questions, even after we go live with this Facebook, you can feel free to still drop comments. We will be answering them for you. And any information given as far as phone numbers and websites will also be detailed on our social media pages. This is Carmen Ramirez and joined by Eric Barber. We'll catch you guys next time on Work Comp Talk.
Thanks.